In this unit, we're going to discuss exceptions and substitutes for consideration. In this subunit, we're going to discuss the UCC exceptions to consideration. In Unit 6, we're going to discuss exceptions and substitutes for consideration. First, we're going to discuss the exceptions for consideration that are in the Uniform Commercial Code. Then we're going to talk about exceptions that are in the common law. We're going to talk about majority approaches and minority approaches. Finally, we're going to talk about promissory estoppel, which is detrimental reliance as a substitute for consideration. Let's begin our discussion of exceptions to consideration that you can find in the Uniform Commercial Code. Remember, the Uniform Commercial Code applies to the sale of goods. Goods are all things that are movable. In the Uniform Commercial Code, you will find two important exceptions to consideration. The first is the modification of contracts. Under the Uniform Commercial Code, the modification of contracts does not require consideration. Secondly, under the Uniform Commercial Code, a promise to keep an offer open by a merchant, we call it a merchant's firm offer, does not need consideration. It is binding even though it is not supported by consideration. Let's look at these in detail. All right, first let's look at 2-209 of the UCC, which deals with modification of contracts. Now, if you read it, it says, an agreement modifying a contract within this article needs no consideration to be binding, which is in sharp contrast to the common law majority approach. Under the common law, a modification of a contract requires consideration. We talked about how that can be done. All right, so even though under the UCC, a modification of a contract does not require consideration, courts have read 2-209 in conjunction with this provision of the UCC in Article 1. Article 1-304 says every duty or contract within the Uniform Commercial Code imposes an obligation of good faith in its performance and enforcement, which means in this case that when you modify a contract, you don't need consideration, but you must modify the contract in good faith. Let's discuss that in detail. All right, so what does it mean to modify a contract in good faith? Well, we know our definition of good faith under the UCC has both a subjective and an objective element. So how do we translate that into modification of a contract? Well, remember, subjective good faith means honesty. So in this case, did you honestly believe that you needed a modification for whatever circumstances, whatever exigency happened, or some sort of other occurrence that required you to ask for a modification? Were you honest in believing that that event necessitated you asking for a modification of the contract? You could also ask, when you requested the modification, were you honest with the other party, or were you disingenuous about the reason you wanted a modification? Did you use some sort of exigency as a pretense for getting a higher price? Finally, there's objective good faith, right? And simply we ask, would a reasonable person in the same circumstances have asked for a modification? So under the UCC, the requirement is that a modification must be done in good faith, and we ask these two questions, or these three questions. All right, let's talk about a threat not to perform in conjunction with a modification of a contract. Let's look at this hypothetical. Seller says to buyer, if you do not agree to a price increase under our existing contract, we will not ship the goods to you. So here we have a threat not to perform. What if the buyer agrees to a modification of a contract? Is that in good faith, right? The buyer, of course, was acting in good faith, but was the seller acting in good faith when they threatened not to perform under the existing contract in order to get the contract modification? Sometimes this is called a threat not to breach, but I don't like to use that language because no one says I threatened to breach the contract. They say I threatened not to perform. All right, so this is the law. A threat is not in good faith unless the seller had a good faith claim that or a good faith belief that she could refuse to perform under the contract because of her interpretation of the language of the contract or because of her interpretation of the law. Later in the semester, we'll talk about circumstances where the law will say you are excused from performance under the contract. So for example, just as a preview, if I agree to sell you a car and a tornado picks up that car and tosses it clear across the county, well, then I am no longer obligated under the contract. I am excused. So here what we're looking for is that the seller who made the threat not to perform unless she received a contract modification, she is not in good faith, she is not acting in good faith unless she had a reasonable and honest interpretation of a contract clause that would give her a right not to perform under whatever circumstances occurred, or that the law, her reasonable and honest interpretation of the law, gave her a right to walk away from the contract if there was no modification. Let's look at our second exception to the consideration doctrine under the Uniform Commercial Code, the merchant's firm offer, which we can find in UCC section 2-205. Now let's refresh our memories. Remember, under the common law, a promise to keep an offer open is not enforceable unless it is supported by consideration. When the promisee does give some sort of consideration for the promisor to keep the offer open, we call that an option contract. So for example, imagine you offer to sell me your house and you promise to keep the offer open for a month. And in return, I give you $100 for you to keep that offer open for the month. Now, because I gave consideration, because I suffered a legal detriment in exchange for your promise, you are bound to keep that offer open for the month. You may not revoke that offer before the month is up. If you do, you are in breach of the contract. This is called an option contract. It's an irrevocable offer because I paid consideration for it. Under the UCC, a firm offer by a merchant to keep an offer open is not revocable just because it doesn't have consideration. It will, the merchant will be bound to keep that offer open even though the promisee gave nothing in exchange. Now, let's look at that provision in detail. Oops, yeah, no consideration necessary. You knew that though. I'm just a little slow today. Let's go through 2-205 in some detail. Remember what we're looking at here. A merchant's promise to keep an offer open will be enforceable even though it's not supported by consideration. So we're expecting to see that pattern in this rule. All right, the first element, it has to be a merchant. It has to be a promise by a merchant, an offer by a merchant. So what is a merchant? Well, a merchant is someone who regularly deals in goods of the kind or holds herself out as having such knowledge. All right, so you'll be looking for facts in your fact pattern that indicates whether the party promising to keep an offer open is a merchant or not. All right, the next element is that the promise to keep the offer open must be written. Here, written is broadly defined. We'll discuss this in more detail later in the semester, but writing or written can include everything from handwriting to typing to email messages to text messages to audio recordings and video recordings. The promise by the merchant to keep the offer open must be in writing, and it also must be signed by the merchant or her agent. The promise to keep an offer open must give assurances that it will be held open. Once again, you're just looking for some sort of promise saying, we will hold this offer open until a certain date. What if the fact pattern just says, this offer is open until? that's probably not enough. That's probably not giving assurances that the offer will be held open. But maybe the facts or circumstances would convince me otherwise. The promise to keep the offer open will be open for the time stated. If a merchant promises to keep an offer open but does not state for how long the offer will be open, then the offer is open for a reasonable time. But in no event may it be open for more than 3 months. 3 months is the outer limit. So look for facts that will indicate to you what a reasonable time is. For example, if the goods are perishable, the promise to keep the offer open will not be open for a very long time. A reasonable time would be a short time. If the goods are technology and the technology rapidly changes, then adjust your reasonable time accordingly. If the goods are selling in a market where the prices are volatile, then the reasonable time might be a short time indeed. If a merchant says, I promise to sell you goods at a certain price and I promise to keep this offer open in a volatile market, the longer that offer is open, the more exposed to risk that merchant is. So you as a reasonable buyer would not expect that offer to be open for a very long time. And so a reasonable time in that situation might be a short time indeed. Keep your eyes open for these types of fact